Your loved one has passed away and left behind property. What do you do next after you've gotten a death certificate? Who is the authorized signatory for estate sales? Anyone over 18 can sign binding documents on their own behalf. But what about the recently deceased? It's important to understand who the authorized signatory of an estate is before proceeding with an estate sale. Who's the executor of the estate? The authorized signatory for a recently deceased individual's estate will vary depending on whether a will exists. If a will exists and is deemed authentic, then the person appointed in the will to handle the estate becomes the executor of the estate. The executor of the estate is the authorized signatory of an estate when a will exists. If a will does not exist, then the deceased individual is classified as having died intestate. In this case, the court will appoint an administrator who will become the authorized signatory of an estate. Do you need an original will for an estate sale? No. If an attorney has seen the original will, they can authenticate and vouch for a copy of the original will. Release both federal and New York estate tax liens before closing. Remember to request a release of lien from the New York State Department of Finance well in advance of your closing. Buyers will need to make sure liens are released for both federal and New York estate tax, or else the buyer could be stuck with any estate tax owed. When should an estate sale happen? An estate sale should happen as soon as possible after death. If real estate is sold within 1 year of death, the IRS typically assumes the sale price is the full market value for the calculation of the estate tax. If the property is sold more than a year after death, an appraisal will need to be done to establish the value at the time of death. This is called a date of death appraisal. Taxable estate versus probate estate. Probate is the public legal process of distributing a decedent's assets to heirs and designated beneficiaries and paying off any debt in accordance to the decedent's will or according to state law if there isn't a will. Because probate is a public process, it can be challenged by someone who wishes to dispute some aspect of the will or the distribution of assets. As a result, many people who wish to avoid potential disputes around their estate after passing away will set up a trust to keep assets private. The trust will pull assets away from the public probate estate. However, just because the assets in a trust are private does not mean that it's not taxable. All assets, including those hidden in a trust, are still part of a decedent's taxable estate. There are two main types of trusts: irrevocable trusts and revocable trusts. An irrevocable trust can't be taken apart or altered after you create it. However, you can move assets in and out of a revocable trust while you're still alive. Have time to manage the sale process yourself? You can save all 6% in broker commission with an agent-assisted FSBO listing. Rather have a professional handle it? You can work with an experienced full-service broker for only a 1% listing fee through Houzit. Learn more at www.houzit.com.